Thank you, Mr. Speaker, sir, for also giving me this opportunity. And I want to take this opportunity and convey my pole to the Deputy President, and we wish him a quick recovery. The impeachment process is always very tedious and very tiring. Going through what His Excellency, the Deputy President, has gone through is not anything that you'd wish your relative or yourself to go through. So we tell him pole, and we wish him a quick recovery. Would have wished if he was here, at least when the senators are talking, he can represent himself. But unfortunately, the procedure must go on because we are time-bound. This leadership, we must make decisions for the people of Kenya. As myself, Stabitha Karanja, the Senator of Nakuru County, I pray to God to give me wisdom to make the right decision for my people. I represent a county that is a home for 42 tribes. Nakuru represents Kenya. Meaning, I must make the right decision to ensure that there is peace in our county. But I want my Nakuru people to trust me, Nakuru people, the people I represent, that I will make the right decision for them. When you look at the economic front, we all know the people who lead the economy of this country. Let's say the manufacturing, the hotels, insurances, the finance institutions. Unfortunately, I also come from that world. I came from the business world. The people driving this economy, all what they want is to ensure that there's stability in this country. So that there's stability that can guarantee conducive environment for them to do business. The deputy position, the deputy president's position, or even the deputy governor's position is a position that we need to think about. If you look, it has a history that every deputy president is unlikely that they survive. But we need to have the firing and hiring to be given to the same person that hires. Rather than having those people bringing, after firing, they want to fire, they bring them to the floor of the Senate. I wish we can go back to the Moi regime, where they used to be sacked and nothing changes. They hire as another one tomorrow, the following morning. Fortunately, the political formation in this country have representation from different communities. I know we are always asking where we are, but when the boss says he doesn't want the person that is hired, a manager, it is very, very hard to say that you can save that person, because even if you save him, where is he going to work? He may even find the offices are locked. So I think you make the right decision to ensure that this country moves, because all what we are looking for is stability of this country. And I know when I'm in this floor, if we're unlikely that we don't save the deputy president of the Republic of Kenya, the one we have, that deputy president came from one community. I just pray that that position will be returned to the same community. Thank you, Mr. Speaker, sir. Asante.
Senator Okoit Omtata.
Thank you, Mr. Speaker. I stand here not to defend a good man. It's not important whether His Excellency the DP is a good man or a bad man. I stand here to defend the oath of office that I took to defend the Constitution of Kenya. And that includes giving the devil his due. When the people of Kenya, during public participation, was screaming Kufa Makanga, Kufa Ndereba. They were opposing selective prosecution. They said if Parliament has to hold people accountable, it should not be selective. And I stand here to look at whether this House has complied with the Constitution. Article 150, Clause 2, on the removal of the Deputy President. The grounds for impeachment are set out in Article 145. And pursuant to Article 145, it is purely a political process, but bound by law, especially Article 25, Clause C, which requires that somebody is given a fair hearing. So the removal of the president by impeachment on any ground under Article 145 is a grave matter that involves overturning the sovereign will of the people as expressed in a democratic election. Even more profoundly, it means that the person so removed is prohibited for life from enjoying the rights under Article 38, Clause 3, Paragraph C, to be elected and hold office, to vie for, be elected and hold office. So the constitutional bar that must be cleared for the removal of the president from office is high. The Constitution requires that the removal must be well-founded in law, and that's why it prescribes the thresholds. And it must be objective. It is not a simple matter of numbers in the National Assembly and in the Senate. An impeachment is not a vote of no confidence. We must distinguish that. A vote of no confidence is a simple matter with no standards. It's just a political thing that you make, and somebody resigns from office, but he can come back and get to office again. This is an impeachment. So, Article 150, Clause 2, provides that to remove the deputy president, the provisions of Article 144 and 145 relating to the removal of the president, the deputy president, of the president shall apply with the necessary modifications to the removal of the deputy president. The Constitution does not anticipate a situation whereby we apply Article 145 on the removal of the deputy president without modifying it. The phrase is, shall apply with necessary modifications. What modifications has this House made, or the National Assembly made, or Parliament as a collective made to Article 145 before applying it to the Deputy President? Can we impeach the Deputy President using the standard for impeaching the President, when we know very well that the President is immune to prosecution, and therefore the certain standards that apply to him won't apply to the Deputy President? So given that the Deputy President has not enjoyed those immunities, how are we protecting him? How are we ensuring that this process is constitutional? It's my submission there's a total failure on Parliament to have proceeded to impeach the Deputy President without making the necessary modifications to Article 145. And you have seen the potholes we have fallen into. It's okay for the President because the President is immune from judicial processes. But is it okay that the Deputy President should be prosecuted using the same standard used for the President? And in the drafters of the Constitution.
Senator Ali Roba.
Thank you very much, Mr. Speaker. I'd like to time so that I don't lose my apologies. Thank you very much, Mr. Speaker. Yesterday, the Council for the Deputy President had really spent a lot of time in trying to bring out non-issues, leaving out the critical substance of the case against the Deputy President. And as I was seated here, I was honestly hoping I'll get an opportunity to get some clarification from the Deputy President. And unfortunately, that never happened. But since we are here and the public are watching, there are issues that need to be responded to. On the issue of serious allegation that is to do with the proceeds of crime and anti-money laundering, in the affidavit of the President, the Deputy President himself acknowledged that Christo Company belongs to him. And he also further acknowledged that he has transferred Christo Company to his sons. And he went further to acknowledge in his own sworn affidavit that he has borrowed 600 million shilling in order to purchase Outspan Hotel from Abadeas. But in the evidence that is filed, that is before us, he only provided a letter of offer from a bank and resolution of the company. But he failed to provide, and all of us understand the loan process and how tedious it is. The Deputy President failed, and if you are accused and you are threatened to be removed from the office of the Deputy President, I believe that the least that was expected of the Deputy President and his legal team is to, get with clarity a closed loop by providing the evidence that is required. For example, there is no provision in that in the evidence and that is filed before us of what happened after an offer was made. Normally it is followed by an agreement, a loan agreement. That evidence of loan agreement has not been filed. It is followed by a collateral document that was used. And, the need to get the collateral document through the legal perfection in terms of valuation report of that asset itself. He has not provided the charge document that indicates that that loan has been charged. In the evidence that is filed, he has not provided evidence of the fact that there is money credited to Christo account. And he has not further provided evidence of money leaving Christo account to go to Abadeas for acquisition of Outspan. And the legal counsel expects, by concentrating on non-issues with the petitioner, that these issues will be swept under the carpet. The other issue that I need to bring out, yesterday we were shown videos. The videos indicated utterances of the president in Muranga, where the president made a statement in trying to validate the statement of shareholding and the country being a company. They showed the president making a statement of nyinyi mumepata share yenu. But that was a statement of inclusivity in context, as opposed to the Deputy President's statement everywhere he has gone, that is, assertive utterance of exclusivity within the population in this republic. Mr. Speaker, sir, Article 145 of the Constitution and 146, 2A indicates that should the unforeseen eventuality happens, where the president ceases to be, God forbid, the Deputy President takes over to finish the term of that presidency. The question I kept on asking myself, can this Deputy President, can I really call this Deputy President my president in the context of this division that has been ongoing? Mr. Speaker, sir, when you are the second in command in the country and you sit